what I'm going to do here, and I don't know exactly how familiar you are with the work of the Hague Conference on Private International Law. It's an international organization who has a very strange name because they started in 51. In fact, the first meetings were in the 19th century, in 1893. And it was, they wanted to build a bridge between common law and civil law, mainly Europe, mainly European countries. But today there are 77 states, and the work of the conference is different and it's more difficult. And their main areas of expertise is children, family law, property relations, contracts. Now they work on a big project that is an American project called the Judgments Project, initiated in '92 by Paul Marin of Harvard, that collapsed in 2001 completely because they couldn't agree on the convention. Now they're restarting slowly and timidly to new binding instrument, much simpler. And again, how the United States and Great Britain common law sees jurisdiction and how civil law sees jurisdictions is a big issue. Well, my team here, what I want, this is just a little bit what they do. They try to do this bridge between common law and civil law. And more, there are less into conflicts of law rules, which was the very beginning of the 20th century, essential to private international law. How do you decide which law to apply to an international case? Well, more and more this is really not important. What is important is jurisdiction, jurisdiction, and jurisdiction. And I guess here too, this is a team. And they developed a lot of expertise in administrative international cooperation between the countries, because this law professor of the past would go and spend many years discussing elaborate conventions, and once they were out and in the countries, nobody knew about it. Nobody knew how to use it, what they were about. And they devised the central authority system, which is like to have an address, a phone, and now an email. Once you have the convention, who do you talk to? Because after all, case people are not specialists. And more, they have a lot of focus on judicial and administrative cooperation. So it's not only the convention, it's not only the law that developed in the international setting, but how you use it in every day. How is it for the people? How to be used? And we're talking about the Child Abduction Convention, which is one of the famous ones because of the highly tragic cases, and especially one with Brazil and the United States, the Sean Goldman case. I think everybody heard of it. For us, it's a shame that there's a Sean Goldman law now. I think it's a real shame to put a law with a child's name, and I won't go into that, but so it's a big thing. And more, they provide technical assistance. They provide what we call post-conventional work. Once the convention is into place, and the Child Abduction Convention is a 1980 convention, the word at the time was that usually fathers would run away with the kids, not mothers. And because of the differences in the systems, because of every judge wants their kids, the nationality principle, once the father would go away with a kid, there was no way of getting it back. Also, international cooperation is highly technical and expensive. The lawyers are expensive, the whole process is expensive, and it takes forever. So once you finally decided on a case, it's been 5 years, 6 years, and the child is gone. It's not a child anymore. So they, with this convention of the 80s, that was their primary concern, the fathers would run away. Now, with the years, it's just the opposite. It's the woman who run away with the kids. Why? Because if you're a foreigner, if you're married in a different country, you don't have your support system, your family, usually like in the States and in Europe, in countries like Brazil and others, the support system is more developed. Here, it's a big thing to have a child and work. It's not easy. I did it. It's not easy, I'm telling you. There's this few years where everything kind of stops, and it's hard to manage everything. And if the marriage don't go well, and you decide to separate it, it's worse if you're foreign. So they want to go back. They just want to go back. And especially, that's a big difference between, I've seen, developed countries and at least Brazil. There's not enough money for the lawyers. I know here you have the right to an attorney for a criminal case, but not to a civil case. Then in alimony, the women don't have lawyers, don't have a support system, anything. And they just want to go away, and they do. And now more and more, because guardianship is trying to be more neutral, divide time equally between the parents, the woman cannot go back at that. But they do, and that's a problem. So the convention now has more problem with the primary caretaker than before. The convention, just a few information, it's been enforced in the United States more than in Brazil, but both countries are a party to the convention and have a different way of dealing with it. And just to give you an example on where the convention is today, it's 93 countries. It's very interesting that the convention is more popular than the Hague Conference as an organization. They only have 77 countries part of the organization because you have to pay to get in, and it's not cheap. And 93 countries are a party to the convention. And Houston runs this. Japan is 98. I want to see how Japan's going to pull. Japan, I know with the United States, has never given a child back. Family law in Japan is totally different. Once they separated, there are no guardianship rights. Fathers are not supposed to have any time with the kids. It's very different. I've been studying, that's a case in Japan, and I was studying their law. It's very different. And I know there are many cases with the United States, and they never gave a child back through international classical corporation channels. Now that they are part of the convention, let's see what happens. But it was last year. And more, this post-conventional work, we're trying to set up a direct participation of judges. Every country who is a party to the convention has a liaison judge type thing. Try to help, so you can imagine a family law judge that has everyday cases, and all of a sudden has this international case. Has no idea how to go. In Brazil, it's the same. And they are trying to develop more, have a judge that would help the information, have judges meet from different countries to solve problems. And once you know the people, once you can get on the phone and talk to somebody you know the face, things work better. And they are also trying to, two things I think it's important that a conference is doing is the good practice guides and the country profile. This is very interesting, country profile, because in the end, the Hague Convention on Child Abduction is a convention on jurisdiction. It's a convention that says that once a child who lives in the United States has been abducted, has been illicitly taken to Brazil, the judge in Brazil can only deal with sending it back. Doesn't have the power to decide guardianship, other rights, anything. Just have to give it back. The primary judge, the judge who has jurisdiction to the case, is the United States judge. And that's wrong. Well, to know if an abduction was illicit, you have to use private international conflict of rules law, in the sense that it is the law of where the residence of the child was. So in Brazil, for a Brazilian judge to decide whether the child was illicitly taken, he has to look at the United States law, the state law, Florida or here or New York or whatever. And at this point, it's very expensive and difficult to know what the law is. So the country profile is a wonderful idea because they have this questionnaire, very detailed. They're very good at The Hague. They have specialists in family law. And you have all the rules, how it is in each country, available in the internet under your small stamp. You have Brazil and you have the questionnaire and you know the rules. And also they decided that very linked to child abductions is child maintenance. So in 2004, they decided to make a new convention on maintenance, which was ready in 2007. It's still not in force, but it's going through. The things are, both subjects are very connected. Well, what about private agreements, which is my talk here? It's just, I won't take so long, but I needed to give this background. Every 5 years, they meet. They have a special commission with the countries who are party to the Child Abduction Convention to discuss what's going on, how is it working, what are the problems. And more, they think one of the biggest problems is sometimes the mother or the parents, the one who goes away, just goes. And then after a while, he wants to come back, he wants to make a deal. Mediation in family law is very important. It's very important here. Why should it be important in the international setting? But they want to put together a package deal. They want to put together and solve all the problems, because the mother sometimes is willing to go back as long as she's living in another house, as long as she knows how the guardianship will be, as long as they divorce. But with the convention, the judge who's dealing with the return has authority only for the return. And if the parties get into an agreement, which is good for the family, it's good for justice, that deals with all aspects of their relationship, you don't know if the judge of the place the child's going back will accept that, will recognize that. Because he may say, I don't care what you deal that in Brazil, now that you're here, I'm the judge, I'm going to decide. So people are very insecure. And they said, we need something for that. So they decided to commission an exploratory work. And the way they work, they set up an expert group. An expert group within the Hague Conference is they try to have a balance of a few countries that they think are important. They try to have a balance between professors and legislators and judges and put everybody on a table together and come up with something that will develop. At this point, they don't even know if they want to develop a binding instrument or a non-binding instrument. This expert group was set up in 2013, had its first meeting in December 2013. I was part as a Brazilian expert, and I've been involved with that. We were supposed to have a second meeting this February, but it wasn't ready. They used to, their technique is that they send out very elaborate questionnaires about the team to the countries. And supposedly when they get back the information, they make an analysis to go forward. It's not easy. The countries do not answer these questionnaires. It's very technical. In Brazil, at least, I'm very in touch with the central authorities. They send me this question and say, would you do that? Sometimes I do, sometimes they don't do it. Anyway, and we have this meeting in December. Because of that, what is that you need to use mediation in these cases? what is that these people need? These people need to solve all their problems, not only the return. And so the group decided that there is need to provide a more effectiveness to private agreements. Another very interesting thing that deals with these comparative law issues. In Brazil, for example, if a family law, in family law and family court, the couple wants to make an agreement dealing with everything, fine. But then it has to go to the judge, stamp it, to see if it's okay. Many countries, you don't need that. The private agreement is really private. It doesn't go to any judge. How do they travel? How would an agreement in a country that doesn't need a judge would be accepted in Brazil? And vice versa, different. Up here is more administrative. In Brazil it's more judicial. Anyway, there's a lot of differences. So we thought in the group that the challenge is to secure recognition and enforcement so the people know that if they get out of the court system and in a table with a mediation to seriously solve their problems, then it won't be a waste of time. When parties, and so we decided that it's a package, and this package must be portable. Oh, now, how? I don't know. We don't know. It's a lot of things to do. And it's non-binding, binding. I'm pro a binding thing. Although binding instruments are very hard to achieve and are long projects, any binding document, any convention in the Hague Conference takes at least 10 years. And then another 10 to be enforced, to be ratified. For example, the 2007 new Convention on Child Maintenance, the United States was heavily involved. They signed it, not yet, up for Congress, up the hill as they call, not yet. It's difficult. The Convention on Choice of Court that the United States was very heavily involved, us as well, it's been up. 2005 or 2015, nothing yet. Apparently, the European Community, no, not apparently, I'm sorry. The European Union has accepted it and that it will be enforced in the European Union this year or next year. 10 years. And the project was the judgment project like 2. So it's long, but still, a binding instrument works the same way for everybody, has a lot of certainty. Non-binding principles are, you work a lot as well, and then you don't know what will happen. So I'm a personally pro-binding. And now, what I think of the future? Well, I'm somebody from both contracts and family law, because I'm totally private international law person. So for me, the system, the method, works both ways. But I do recognize that business people are a certain bunch, and they operate, they have a frame of mind for business, while family law is different. Business, party autonomy, the possibility of choosing the law, of designing your contracts and what you want, or putting into your contracts the whole law for yourself. It's common and it's very well accepted. While in family law, the state thinks they have the upper hand. They want to get more involved, and they don't let the people decide as much. However, more and more, especially in international setting, party autonomy is going to family law as well, especially when you have patrimonial problems. So you have the Hague Conference on matrimonial regimes that accept that the parties choose the law. In the Maintenance Convention, the protocol on the applicable law has a provision for the parties to choose the law they want. But party autonomy in family matters is more of a choice between two previously set rules. While in contracts, pretty much everything you want, a third party, a neutral thing, like the Zapata versus Bremen case of the 70s here, choice of court. It was England. England had nothing to do with it, but it's okay because you're in business and you want a neutral forum. So family law is more either nationality, either residence. However, I think this both words can collide. They can work together. They can talk to each other. And my personal suggestion, I like this audience because I can put it down and I have been not, and see if it sticks. I think we should use the same technique we use for choice of court, for the clause which has a choice of court, in contracts as in family. How? The choice of court convention, the Hague Choice of Court Convention, has a very interesting setup. If you have in a court contract, if you choose a court in a contract in countries that are a party to the convention, the judge where you chosen by you, cannot refuse the case. The judge that was not chosen should refuse the case. And then the third judge, who would somehow need to recognize a judgment that comes from a place where you have chosen and was under the rules of the convention, cannot say he will not enforce it. So the system goes, there's a lot of exceptions, public policy, but that's the system. 3 rules. Well, why not make something with the same 3 rules for private agreement? If you, under certain rules, as a family, have a problem related to child abduction, set up in a table with a mediation, have a reasonable agreement under the law where you're doing it, following whatever you need to follow, stand by the judge, not stand by the judge, seen by a notary, within a few days, whatever the rules you need. But then it's valid, it's legal. Why wouldn't this document be respected and prevail in the country where it has to go? If it's legal under the country that it was done, then it should be automatically recognized in the country where it's going, if there are parties to the convention. And a third country, if you need to, should not try to say, oh, they couldn't do that. Should accept that, should recognize it. And the country where the child is going, if there is this agreement in country A, country B cannot say, oh, I don't respect that, I should do it. No, you shouldn't. It's done already. So I don't know. Doesn't want me to do anything. So I think we could use this relationship. I think we could draw for the example of the choice of court convention for the family matters. I think that's a way to the future. I don't know. It's still very in the beginning. We just had one meeting. We just acknowledged the problems, the need for regulation for the package and not just for one thing. The Hague Conference has 3 conventions for children. The child abduction, maintenance, and the one on guardianship. And each of them deal with separate things. We need something that will deal with the whole situation. A family is not one point. A family, when they have a problem, when they sit down, they have a bunch of problems. They want to solve them all together. And that's how it goes in family court here. If a couple is splitting, they will sit down and they decide everything. Guardianship, matrimonial matters, property, the future, name, everything. Why should it be different in the international setting? Why shouldn't we respect this option? So I don't know how this will go, but I'm putting forward this idea to use at least some of the rules we already have in contracts for this matter. That's my idea. Thank you very much.
Thank you very much for for those very interesting remarks, which are also on the cutting edge, because this is an agreement that has yet to occur. It probably will be 10 years before it's binding on everybody.
I have a lot to do.
So we have an opportunity to influence the future, and our speaker is willing to take questions, and I see that there are some. So Professor Grossman.
Okay, well, thank you very much for the remarks. Very interesting. I wanted to, we actually, in Conflict of Laws, we do a case where, and actually Christian might remember it, where there's a, right, where there is a agreement made by a man, a lawyer, and his secretary who had a child together, and so it's a maintenance agreement, and it's made in Illinois. It's like in the 1960s, and the agreement contains a choice of law clause for Illinois. But then they go to New York, or she goes to New York, and she tries to change the terms of the agreement. And the New York court has to decide whether it's going to accept the choice of law clause that's found in the agreement from Illinois. So in some ways it's quite similar to what you're suggesting. And so the thing that keeps popping into my head is, how do you deal with the public policy exception? In other words, in all of these, you could have these rules, but courts could always just say, this violates our public policy, and then do whatever they want. So how much predictability and uniformity would your proposal actually create?
There's no way you can have a convention without a public policy exception. The thing is how to...
Nor would we want one, right?
Nor
because
would you want
if there's
one.
an agreement in
There's-
Saudi Arabia that uses their
Yes.
law, and then they, people
And
negotiate
the
in that
Child Abduction
context.
Convention has a public policy, and it has Article 13b if there is a problem with the child, if there is violence, anything. The judge who decides on the return, and that's one of the biggest paradox of the convention. In one side, they want the child to be back in 6 weeks. The other hand, the parent who took the child has the right of a hearing, has the right to prove there was motive, because there are exceptions to the prompt return. So there's no way we will avoid everything. Public policy has to be the more and more frame to be an exception. That's as far as we can go. It's an exception. And then it's a lot of evidence, it's a lot of expert testimony. It's hard, but there's no one answer to that. And you are always on the feeling of the judge, and some are more open, some are not. But the more you have, for the Child Abduction Convention, they have INCADAT. They have a system that puts together all the case law in many countries. The more and more you decide pro-convention, the less abductions you have. It's a deterrence effect. But no, I don't have an answer for that. I mean, there will always be the public policy, but if you have a convention, and the choice of court convention has a public policy perception as well. I didn't go into that.
Yeah, I mean, that's true, but in the context of family law, my sense is that courts are more willing to assert the public policy exception because they're thinking about relationships among people that are sort of at the heart of the society, that we're talking about. So it seems like that exception could be invoked much more frequently in this context than in...
I agree with you. I just want to point out that as lawyers, as professors, all we have is the worst cases. And now, I wasn't a lawyer. I was a prosecutor for 30 years, and I retired, and I opened a small law firm. And I'm advising a lot of people on cases like that. The fact that you have the legislation will work well for a lot of people that are willing to comply and will not go to court. We only see the worst cases, and so we get a little twisted. That's my answer. The public policy issue is a big issue. There's no answer to that.
Thank you.
Okay, but still, the fact that you have a clear legislation, a lot of people will benefit it, because you have now the Child Abduction Convention, a lot of people is not just leaving. They're trying to talk about it before, they're trying to reach an agreement before, because now they know that if they fly, they're gonna get caught and the whole thing. But, of course, we only have the worst cases.
Professor Giles.
So we couldn't be farther from my area of expertise.
Okay, which is?
I do criminal law. And,
Okay,
you know,
well,
so-
in here, child abduction is a crime.
Well, so,
Not in Brazil, though.
and I see it through the lens a little bit of an area I did have to practice in, which dealt with domestic violence and issues like that. And so I wanted to push back a little bit because I question some of the presumptions that underlie the idea that we say under contract law that private parties can make these kinds of decisions. And there are certain presumptions I think we make about their ability to walk away from the deal, about equal bargaining power, and issues like that that simply don't necessarily hold up. And you know, the allegation that is frequently brought up in these abduction cases, as I understand it, is allegations of violence and allegations of either
It's the
financial.
13B.
Right.
Yes.
So it may be that there are enough exceptions that can eliminate some of these problems we have. But it occurs to me there is a strong critique of mediation in family law in this country because there's growing recognition that mediation has actually maintained power imbalances, and actually I think studies show that women did remarkably worse under a mediated regime than they did when they actually litigated. And so I just wonder how whether or not there's some degree to which it's an idealistic view of what mediation accomplishes. And at the end, I think I very much favor your project, and I do want people to be able to work it out, and just fleeing to another jurisdiction doesn't seem like a solution. But it seems like a lot rides on the ability to collaterally attack whatever mediation agreement there is based on these things. And the more you can legitimately attack it for problems, the less this really works out in the end. So I'm not sure how to resolve that. That was a little rambling.
I don't say mediation is the solution, but I have to say that in international cases, everything is so expensive and so far away, and all the problems you have between states, but you still are in the same country. But while you're dealing with another country, with another jurisdiction, everybody's so afraid to let go, that even a bad mediated agreement is better than nothing. What I see is somebody who left. I now advise on a case. There's Terry, you want to cry. She sent me a message to Skype the other day, I wanted to cry. It's a Brazilian who married an Italian. They have 2 kids. She went there to live with him. After a while, she didn't want to. They came to Brazil. He came with her. They stayed in Brazil for a year. And he wanted to go back. So he took the oldest kid with him and said, oh, I'm going to see my parents, but enrolled him in a school, and she tried to go there, and he started a guardianship case in Italy. And Italian court thinks nobody should live but in Italy if you're Italian. Simple, right? No woman, man, or whatever, it's just like Italian. And then in Brazil, according to the convention, they have residency there. So the central authority in Brazil ruled that she was not abducting one of the children. She was okay. So right now she has a case in Italy. She cannot see her oldest son. He's living with his dad. And she's with one of them, and the brother is separated. And there's no solution because Italian courts see things in a certain way, Brazilian courts see in a totally different way, and there's no way they will reconcile. So they have to reach an agreement.
I agree, although I don't know if that example, they're not mediating.
No, they're not, but they're not, and there's not also a solution with mediation, because if they did, if they did mediate in Brazil, doesn't mean the Italian judge would accept it. at all, because he doesn't think Brazilian judge has jurisdiction under the convention.
Why doesn't he think the Brazilian judge has jurisdiction?
Because he has not. The convention only talks about the return. If they decide, they say the judge of the residences is the only one who can judge on guardianship. So if there was an agreement on guardianship in Brazil, it doesn't mean the Italian judge would accept that. That's how it is now. So although I do see,
But the only way that gets to that judge is if the father is essentially trying to break the agreement, right?
right.
So,
But if you have a convention where he cannot break the agreement, you are a little more protected than now.
I don't want to hold the floor.
No, it's a tough issue. I agree. Women are in the worst position ever in all these things. And so we have to move forward and guarantee how is this mediation process going to be. And there's a lot of other problems. Our expert, one thing you need to learn when you work with the Hague Conference, you stick to your mandate. Our mandate was really just to deal with this recognition and enforcement. So if you should try to go too far and you don't get anywhere.
Professor Peters.
Thank you, and thank you for the really interesting talk. And I apologize, I'm going to have to leave in a few minutes, so I'm going to commit to the cardinal sin of academia, which is ask a question, get the answer, then walk out. I apologize for that in advance. This is really a follow-up on what David asked, and to some extent related to what Nikkei asked as well, because I too thought about the potential distinction between the commercial context and the family law context, or distinctions, plural, which is, I think, the analogy you want to draw. And the bargaining power problem occurred to me too. The other problem that occurred to me was the idea that when you are dealing with child custody, you have this third party who is a minor by definition in these problems, and therefore his or her interests are being affected, but he or she is not a party to the negotiation. And I'm probably farther away from family law as an expertise than David is, but I know that we have the standard, at least in this country, of best interest of the child, right?
Yeah, we have that, and the convention has it as well.
So that strikes me as another distinction or potential distinction between the family law context, especially when children are involved, in the commercial context, where you don't have the equivalent of the child whose interests are at stake, that the court has to sort of look out for. And so maybe the way to ask this is to ask, are there ways, rather than to present this as a worry about the project, are there ways that the convention can take account of these kinds of worries in the convention itself? For instance,
yes.
Minimum substantive
Yes,
requirements.
we are still in the very beginning. Like the expert group just recognized that we should try to find a solution.
Mm-hmm.
And within our mandate, we're still only dealing with whether we should go binding or non-binding. Once we start with a project for a convention, of course, these 3 rules of the choice of court is just the beginning. But of course, we need, how's the mediation, if we're going to have some mature rules on the mediation, on protection, on public policy, and take into the interest of the child into the public policy, and like the judge who would receive this mediated agreement would be able not to recognize it if it was against public policy, if there is a degree of evidence on whether something has happened.
Mm-hmm.
I mean, you can't just say it's okay. I recognize it's very different from contracts. I'm just saying that we could draw from the design of that framework for this one, the main rules. And then we have to work out a lot of things. And I'm glad you have not dismissed completely my idea, saying, no, it's so crazy. It's just very in the beginning. But I understand, I totally agree with you and the difficulties, and we need to, what happened is, if you look at the Hague Conventions of the first quarter of the century, the first half, until the 80s, the conventions were very beautiful. A few articles, clear rules, so easy. Now, God, you have no idea how it goes. The Convention on Child Maintenance has 60 articles. Every article has 10, 15 items. Everything they could not agree on is on the report. Like, 60, 70 states, just different backgrounds and everything. And in a way, the Hague Conference is a victim of its own success. Because when it was mostly European and a little bit of common law, fine. Pretty much the ideas were around the same areas. But now it's like, it's very hard to move forward. It's very frustrating. I've been there, and it's like, and what's funny is like a special commission would meet every year, and they would discuss something, and they would reach a compromise, and you think it's over. Then you come back the next year, and the same delegate starts all over again. It's like, we decided that last year.
That's called a faculty meeting.
So but it's just to use some of that framework and try to adapt. Of course we need to take into account that we're dealing with the child, the best interest of the child. I don't know how we could somehow have in the convention a few basic rules, material rules for the mediation, that a mediation would have certain standards to be recognized, not whatever. I don't know.
Well, good luck.
It's a long word. Well, fortunately, you can write about it all your life. No.
Is that side of faculty?
Yeah, because it's something that grows. But it's very interesting to sit with all the people from the other countries. From the United States, there was a judge from Florida. She brought very interesting ideas. And then there's a professor from Aberdeen, Paul Beaumont, he's in The Hague all around.
Yeah, we know him because he was also a visitor here.
He was. Paul's very funny. He's a great guy. But he's in all Hague projects. I mean, I think that's pretty much what he does, because he has a lot of. And then he's in the surrogacy project, and this project was the maintenance, everything. And a lot of people.
Professor Rosen.
I want to ask you about the map you put up.
Okay. The map.
Yeah. Which I noticed that there were the U.S., South America, North, South, Central America,
No
Europe,
Africa.
no Africa, no Middle East, and I was wondering why? What?
Oh, why? Because family law in the Middle East, forget it. It's like
Okay.
they won't accept anything.
By the way, it was true.
Huh?
You use on that map a light blue and
Yeah.
I have to
Not
say, I got that map
a,
from the internet as a map of the convention. So it's not, it was just very pictorial, but it's not.
but do you know what do they mean?
Yeah.
The light blue and dark blue.
I think I do. There's. I think the light blue are countries who have signed but are not yet in. They're coming, because in the convention system, if you make an addition to the convention, the other countries have to accept you, and sometimes there are a few years before you're completely in the system. And the blue, dark blue is the ones we're in, and the gray is the ones we're not.
Yeah, see, 213 has Republic of Korea, and that corresponds to the light blue over
Yeah,
Asia.
see? So, and it's funny because there are more than the countries that are in the Hague Conference. They have 77 states, 92 countries, parties. Africa is coming. They're making a big push through Asia. They open a regional office in Hong Kong. But it's very European yet. And for me, personally, I don't like the conference at these days because the European Union is a party. So they vote. They don't vote. See, they decided they don't want to vote. They don't vote. They have to reach consensus, which is good because when you have consensus, it means everybody's on board. Which is bad because to reach consensus, a lot of things cannot get in and they go to the report, which is nothing, right? Every convention has a rapporteur who writes a very elaborate report. There's a lot of things they explain in the report. There's not in the law. And it's apparently your first legislative history place to go is the report. But the report is not the law. So consensus now makes the wording so vague sometimes, so broad. It's hard. And then the European Union, they are there as one, but they're not one, they're 28. And the countries are shut up, like England, like France. They're there, but they cannot disagree with the European Union. So what they do, they work double because they have these coordination meetings before the meeting and afterwards. So like they're always on meetings. It's hard. It's hard not to listen to traditional countries that have a standing on international law, private international law, who were founders of the Hague Conference, and now, because they belong to the European Union, they're the ones who talk. So I don't like that so much. We, the Latins, we finally put our act together, and we have a GRULAC. We have a try to stand as a group, but it's different.
On the South American map, is that Colombia in the light blue?
That's Venezuela or Colombia? I'm not sure. No,
white
Venezuela is this one.
Yeah.
I think it's Colombia.
And the one that isn't a party below?
That's Ecuador.
Ecuador.
Isn't that Bolivia?
I think it's Bolivia.
Bolivia, no, Bolivia is, I'm not
That's
sure.
Paraguay.
No,
Uruguay?
you're right. Ecuador
That's Bolivia because
is
it's
small.
landlocked.
That's Bolivia. That's Bolivia. And that's one
Well,
of the Guianas.
Maybe it's landlocked, depends on your view.
Definitely landlocked.
It's just a matter, I know this is just a matter to show you, to have a sense of how we have it so clearly in the Americas, where you have common law and civil law, and how you have in Europe, and how Asia and these traditional countries that have a different type of law or family law are really not in. They are not. Africa, it's a problem.
So we have time for one last question. I'm going to ask it.
Sure.
On the choice of court convention analogy, which you offered to us, you said, would it be nice to think about it like the choice of court convention? I think it's a good analogy, but I think that how that analogy plays out depends on the moment in time at which you're thinking about it. Because the Hague Convention on Child Abduction, the Child Abduction Convention, in effect sets up a parallel regime to the Choice of Court Convention. They say, by living in a place, you have nominated that place as the place that is where the decisions get made. So it is the same, but that's at one point in time, and now you're saying at a second, later point in time, after the abduction, they should be able to renominate. But that actually maybe defeats the purpose of the first nomination, because by renominating, once you're, let's say, so if you steal the child and you take it to another country, and then you get to do the mediation in the country where you stole the child and removed them to, you run into the problem that you were discussing with the Italian court. You always get a better deal where you are. They shouldn't get the benefit of that.
I know, it looks like if you have a convention with the choice of court, with the enforcement of the private agreement, that was done only after the abduction. You are pro-abduction in a way, I understand that. But families, they're very unstable. I think the courts are not ready for what happens. I was a criminal prosecutor. I had a lot of stabbing of women and everything. And after they want to drop, and a few years later, they're friends again. The guy tried to kill you, and you're friends with him again. How can you judge that? You have to have a way out when they're ready to get to an agreement, because if not, if the judge decides and nobody's satisfied, it's still a problem for the family. I do understand. There's a lot of people against this project because of that. They're saying what you're doing is, in the end, it's good to go away because you have the upper hand, and you do, and the other party gets so tired of the fighting, has no resources for the fight, and I talk about the parent, the father as well. I mean, it's very expensive, even if you have the central authority doing it for you. It's very expensive to litigate. See, in Brazil, it's a little better because we have public defender for family cases. And the public defender in Brasilia, they usually need a level of how much you make. But the public defender's office in Brasilia decided that for child abduction cases, especially if it's the woman involved, they defend her no matter how much she has or she makes. And they defend both sides. So they would assign a different defender for the mother and a different one for the father. They would give it for free. And it's not the same elsewhere. So it's, at this point, if a case is coming to Brazil, the parties have more resources to deal with it in the court system than if it's somebody going to the United States where you have no lawyer. No lawyer. So I know what you're saying, but I just feel, I don't feel this project is for everything. I just feel there is a group of people that heal afterwards as a family and are ready to make something, and we should give them this chance. But it's a problem.
Well, thank you very much for these very perceptive and very interesting remarks, and we're very grateful to have you again at the University of Baltimore. Thank you.
And you can circulate if you want. I wrote a little piece with a little more information on this cross-border recognition enforcement. I think I send you